This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Is the petitioners before your lordship are state qualified candidates. They participate in the recruitment process initiated by the West Bengal Board of Primary Education by a notification dated 29th September 2022, my lord. Well, later, by a notification dated 21st of October 2022, detailed vacancy position and recruitment rules were published. The petitioner filled up the online application form and participated in the selection process, my lord. The total number of vacancy in the said selection process was
in which district? In all districts?
All district, my lord. 11,760.
Now, whether the petitioner, some of the petitioners are coming from a district which comes under the jurisdiction of Jalpaiguri Circuit Bench.
That, my lord, I need to
find it out. They are to be excluded.
Raiganj is under Uttar Dinajpur. Uttar Dinajpur is not under the circuit bench. No, my lord. Perhaps, my lord, none of these petitioners are coming under the territory of circuit bench of Jalpaiguri, my lord. Most of them are from Murshidabad.
Yes.
May I please? My lord, later, my lord, vacancy position was declared and recruitment rules were published. My lord, total number of vacancies were 11,765. My lord, a corrigenda was published by notification dated 10th of December 2022, thereby excluding some of the vacancies since order was passed to grant appointment in respect of some writ petition. So 93 vacancies was excluded. My lord, this petitioner participated in the selection process and they filled up the online application
form. Selection process of
2022.
Yes. Well, participate in a selection process then?
Yes, my lord. My lord, in this time, my lord, it is important to place before your lordship that candidates who belong to 2020 to 2022 DLED courts pursuing candidates preferred writ petition before this Honorable High Court, stating that their course should have been complete between 30th June 2022, but that has not been done by the authority. So they should be allowed to participate in any future recruitment process and they should be granted training completion certificate expeditiously. Well, a submission was made before the Honorable High Court by the board that they will allow these candidates, 2022 training pursuing candidates, in any future recruitment process. That submission was made before this Honorable Court and writ petition was disposed of by the same line on 29th of September 2022. That is the same date when this recruitment notification came. So order allowing the 2022 DLED degree holder to participate in a future recruitment process and the recruitment notification came in a same date, my lord. So we are not under the 2022 diploma degree holder. We are trained much prior to that. But we have participated in the recruitment process and we have been called for interview process. We participated in the interview process. My lord, interview notification came in the month of December 2022, my lord. My lord, by this time, what happened, my lord? Order of single bench, honorable single bench, allowing the candidates who are 2022 diploma degree holder was challenged before
2022.
Yes, not us. Order of that writ petition was challenged in 3 different appeals before the Honorable Division Bench. Well, Division Bench by a common judgment dated 11th of April 2023 set aside the order of the single bench as well as the notification of the board whereby they allowed to participate those candidates. So Division Bench excluded those candidates who are diploma degree holder of 2020 and 2022. The original writ petitioner of those petitions, they preferred SLP before the Honorable Supreme Court, challenging the order passed by the Honorable Division Bench, my lord. By this time, my lord, we have completed, we have been called on and we have our interview process, document verification, everything has been done. My lord, before the Honorable Supreme Court, my lord, on January 24, precisely on 22nd January 2024, my lord, direction to file affidavit was passed upon the West Bengal Board of Primary Education, stating that you disclose all the details regarding this selection process, how many candidates appeared, how many of them have made to filled up in the process till now, and how many have been excluded since they were 2020 and 2022 diploma degree. Yes, my lord. My lord, thereafter, on 29th of January 2024, my lord, board filed their affidavit pursuant to the direction of the Honorable Supreme Court. Thereby, they stated that between 11,692 vacancies, they find 9,533, that is 9,533 candidates to be eligible to get in the merit list. And they also categorize us as an unobserved candidate. So, a specific paragraph in the affidavit, that is paragraph 16, they have stated before the Supreme Court that these candidates could not meet in the merit list, that is 9,533 out of 11,000 and odd. So, our score was also submitted before the Honorable Supreme Court. Details of each of us and our score was submitted before the Honorable Supreme Court. Now, Honorable Supreme Court on 29th of January 2024 was pleased to direct the board to take interview of 2020-2022 DLED batch. Pursuant to that order, my lord, in the month of February 2024, board issued interview notification for those petitioners who have been excluded by the division bench and who preferred SLP before the Honorable Supreme Court. So after their interview, my lord, finally, the matter was disposed of by Honorable Supreme Court by the judgment dated 4th of April 2025. Well, this 4th of April 2025, Honorable Supreme Court allowed the SLP, stating that this candidate should also be in the merit list, my lord. My lord, if I, Lordship, my lord kindly takes up the order passed by the Honorable Supreme Court, that is at page 102 first. Paragraph 4 states, my lord,
So report was to be submitted.
yes, my lord. But they have preferred subsequently. They have filed their report also. My lord, paragraph 5, your lordship will see that the remaining posts shall be kept vacant and are made subject to the further orders that may be passed by this court, my lord. Thereafter, when the matter was disposed of by the Honorable Supreme Court, that is on 4th of April 2025, my lord, I am relying upon paragraphs 21, 32, 33, 34 of that judgment passed by the Honorable Supreme Court.
Page
215 and 225.
order starts from which page?
Well, order starts from page
195.
Yes, your lordship. Yes, 195.
Yes.
I'm relying upon paragraph number 34, the last paragraph, my lord. Here my case arise. That is 226.
Yes.
May I place? Our consideration was confined to examine the legality and validity of the judgment and order passed by the division bench of the High Court. All applications for implement are dismissed as withdrawn. The applicants are permitted to avail such remedies as are available to them in law. If remedies are invoked, their prayers will be considered and disposed of by the respective courts or tribunals on their own merits, my lord. My lord, here, my lord, before the Honorable Supreme Court, we have preferred implement applications, stating thereby that we have come under the zone of consideration, since in the affidavit filed by the board, they itself stated that we are the unobserved candidates, and a list was submitted also, since in the cutoff score, we could not meet the cutoff score, and post or remain unfulfilled for the candidates of 20 and 2022 diploma degree holders and us.
So your implement applications were withdrawn, and
withdrawn as dismissed.
applicants are permitted to avail such remedies as are available to them in law if remedies are invoked.
Yes, and
Now you have filed this writ petition.
yes, and by
Seeking what? Seeking what?
Seeking what? Well, to fill up the unfulfilled vacancies taking into consideration our merit and those candidates who are of 2020 and 2022 diploma degree holders. Since the Honorable Supreme Court had stated, directed the board to conclude the selection process as expeditiously as possible. That is paragraph 33, my lord. Same judgment.
No, but their right was already decided by the Honorable Division.
Yes.
Your right has not been decided.
My lord.
Their right was decided that they will be permitted to participate in the interview and they are to be considered for the said selection process of 2022.
Yes, and that has to be considered in accordance with merit.
What is the stand of the board?
First of all, I have 2-3 submission. First of all, my learned friend has shown the paragraph 34. Before that, paragraph 33, this judgment, the Supreme Court has part Article 142, paragraph 33. My learned friend is relying on paragraph 34.
33 also.
34 also. The applicants are permitted to avail such remedies as are available to them in law. My lord, I am joining here an issue, my lord, that after expiry of panel, my lord, he cannot come. My lord, as per in law means, my lord, the settled principle of law. My lord,
they did not participate in the selection process.
The panel has expired. But after expiring of panel, my lord, one cannot, my lord, a fence sitter, my lord, observing everything.
They participate in the selection process.
Participated. Result was published. Appointments were made. Panel was valid for 1 year. Thereafter, panel expired. But after expiration of everything, my lord, they have come before your lordship. My lord, they could have, my lord, got this, my lord, order from the Supreme Court. My lord, Supreme Court has not, my lord, given anything, my lord. Dismiss the, my lord, application.
Supreme Court has granted.
As per law.
Yes,
in law.
Remedies are invoked. The prayers will be considered and disposed of by the respective courts or tribunals on their own merits. So
On
matter
own
needs
merits.
to be considered. Issue is wide open.
And they mean law, my lord. In law, my lord, they are not permitted because, my lord, law says panel is valid for 1 year.
Is it your case that all the posts are filled up?
My lord, there is, my lord, the history, my lord. My lord, the initially, my lord, order of the Supreme Court, interim order of this on the Supreme Court, my lord, the 9,000 and odd posts were filled up. My lord, 9,000 and odd were filled up. My lord, the rest were there. My lord, Supreme Court permitted us to fill up the, my lord. After that, my lord, this order has come. My lord, this, my lord,
Now
this
the
is
candidates who
only
from 2020, 2022
Exactly.
DLED batch,
yes.
they were permitted to participate and they were appointed.
No, not yet. Not yet appointed. After this order, my lord, this order is came, my lord, only on, my lord, 4th April, my lord, of this, my lord. My lord, we are, my lord, working on that. My lord, will take steps, my lord, in accordance with law as per the order of this, my lord, this order, my lord, the Supreme Court. My lord, my lord, neither they filed any, my lord, petition nor is pending. They are only, my lord,
No, but they preferred the implement application.
implement that was dismissed.
Withdrawn.
It is not a dismissal, simplicity, Mr. Vishwas.
My lord, with the
I'm
rider.
repeating, all applications are implemented, dismissed
Yes.
as withdrawn.
Yes.
The applicants are permitted to avail such remedies as available to them.
In law. My lord,
Yes.
in law.
Now issue is open.
My lord.
We have to demonstrate before this court that why their claim will not be considered.
My lord, then I will-
Since they participated in the interview, you participated in
Yes.
the interview.
My score has been given to the Supreme Court also. I am stating that if I am more meritorious than those candidates who belong to 2020 and 2022 diploma degree holder, then I should be considered. That is the order in paragraph 33.
Now, apart from no appointments have been given from this panel.
No. Panel appointments were made. My lord, total vacancies were 11,000 and odd.
Yes.
My lord, 9,000 and odd were appointed already. Except, my lord, those who were the batch of 2022.
All appointments were given.
Except 2022 batch, all appointments were made.
So, whether any posts were kept vacant
that
for
is-
this 2022 batch.
My lord, that is, my lord, the board is working on it after getting this
No, if
judgment.
all appointments are given,
My lord.
in that event, how these candidates from this 2022 batch to be accommodated in the panel
My lord, that
or
is,
to be accommodated
my lord, that
by
is-
giving appointment.
my lord, that is, my lord, the board is working on it. How this, my lord, order will be implemented. My lord, that is board is, my lord, on working, my lord. My lord,
Your
that is-
contention is this 11,000 vacancies have been filled up.
No, not 11,000. Out of 11,000, 900 and odd were filled up.
900.
9,000 and odd. Sorry, my lord. 9,000 and odd were filled up. That is, my lord, pursuant to the order of the Supreme Court.
So therefore, approximately 2,000 odd vacancies are lying.
My lord, line. But my lord, category A, my lord, medium category, my lord, all together, my lord, 2000 and odd, my
Or
lord.
vacancies are there. Now, whether these candidates,
Less than 2000, my
if
lord.
they come within the zone of consideration, and the candidates who are from 2022 batch, they are to be accommodated against this 2000 odd vacancies.
Yes, that is my case.
My lord.
Now they are claiming that if they are better candidate than this 2022
Cannot be,
batch,
my lord.
why they will not be considered?
Cannot be, my lord, because, my lord, we have to, my lord, first comply with the order of the Honorable Supreme Court.
The Supreme Court has directed to
My
give
lord,
them appointment.
No, no.
To consider them.
No, Supreme Court has not passed any order so far the merit is concerned in their favor. In the
Only Supreme Court has decided that their candidature are to be considered along with other candidates.
Not only, my lord, kindly see, my lord, not
Because previously it was decided by the district primaries by the board that these 2022 batch candidates are to be excluded. Now they are included and they are to be considered. Now, whether by virtue of the order of the Honorable Supreme Court, the merit of other candidates can be given go by in deciding their entitlement to be appointed.
My lord,
And entitlement to be appointed in the post of primary teachers.
First of all, my lord, they are not the batch of, my lord, 2022.
Maybe, but it is not your case that this selection process is exclusively confined to 2022 batch. You have given an appointment to 9,000 candidates from other batch, previous batches.
No, they were entitled as per the law.
Yes, they participated, but they did not come within the zone of consideration out of this 9,000.
No, my lord, probably, my lord, I'm not, my lord, make myself clear, my lord.
Yes.
My lord, initially, my lord, vacancy were 11,000 and odd. My lord, advertisement was made. My lord, the board permitted, what was the advertisement? My lord, I have to first, my lord,
No, 11,000 and odd vacancies were advertised, out of which it was the decision of the board not to include 2022 batch.
Initially, no.
My lord, initially, no.
My lord, may I give a picture to this? I tell you, losses. Board decided in the 2022 recruitment process that apart from the other TET qualified and trained candidates, undergoing 2022
Will not be
candidates
included.
will be allowed, and this was allowed by the learned single judge.
Then division bench said no.
No, you
Against
cannot.
that, appeal was
Supreme
preferred.
Court.
Supreme Court said no, they are to be allowed.
Ultimately, my lord, they have to be considered.
Yes. So the decision of the board remains ultimately.
Ultimately,
By virtue of the order of the Supreme Court.
But what happens in the meantime? In the meantime, Supreme Court allowed 9,500 candidates to be appointed. They have been appointed. Somebody have been
Now the
confirmed.
petitioners are not from the batch of 2022.
No.
They are coming from previous batches. Now, therefore, initially and even after the order passed by the Supreme Court, there was no embargo. So far, petitioners consideration of candidature of the petitioner.
Now, point is here, when the 9,500 candidates were considered on merit, they did not come. They did not come.
Now their right is why their right will not be considered to the extent of these 2,000 candidates, 2,000 odd candidates.
Here your lordships, there are other interim orders.
Because think about this, Mr. Sannal. If your first decision was this, that this undergoing candidates, the candidates who are undergoing or pursuing DLED course for the session 2020-2022, they are to be considered. Now, coordinate bench said yes, they are to be considered. Division bench said no, they are to be excluded. Ultimately, Supreme Court says no, their candidature is to be considered.
142. Supreme Court applied 142.
They cannot steal a march by virtue of the order of the Supreme Court in connection with these 2,000 vacancies which are remaining, because there shall be consideration of inter se merits of all the candidates who participated in the selection process.
I tell you, losses, there are certain gray area. If your losses strictly apply the law, situation will be one. And if your losses consider the judgment of the Supreme Court, situation might take a different
if
turn.
I go back to the situation in view of the notification dated 29 September 2022, then all candidates, including pursuing DLED candidates who are pursuing DLED course for the session 2020-2022 were to be considered. Now, if that situation remained, then in terms of merit, appointments are to be made. suppose a candidate A is coming from 2022 batch. Another candidate B is coming, is one of the petitioners. Now, if B scores higher than A, then why the right of
That's
B
why I'm saying,
will be ignored?
Malad, this is not this type of cases. There are at least 5-6 type of cases will come up because of this proceedings and 142 judgment of the Honorable Supreme Court. Now, others, I tell you, Lordships, somebody, Malad, initially this order confined to the appellants who were before the Supreme Court. Now, while passing the final order, Supreme Court kept mum. Then there are other candidates.
So Supreme Court granted them leave to approach the court in accordance.
That's another point, your Lordships. Approach. Then it will be a never-ending process of selection, my lord. Board has to apply its mind.
No, but
How
how
it
to
is to be
demonstrate
said.
before this court that by virtue of the order of the Honorable Supreme Court passed on 4th April 2025, only these candidates are to be considered who are pursuing DLED course. If you can demonstrate, then they have no, petitioners have no case.
Well, that's Malad. We are thinking of it. We are working on it. It will take little time because particularly there are other persons who will come up. Certainly approach the court.
If you can approach this court, if you can satisfy the query of this court, no. In terms of this order dated 4th April 2025, only this candidate category of candidates who were pursuing DLED course for the session 2020-2022 are to be considered, none other. Then yes, if court satisfied, then the court will accept your contention.
Well,
but if it is not, if these vacancies are wide open for all categories of candidates, then why these candidates will, those who are left out while giving appointment of 9,000 candidates are not to be considered.
I'm getting your losses point, but I'm not too wide opening my mouth today because there are other considerations.
I am fixing the matter after vacation.
Yes, that should be because right now nothing is happening.
Yes. But in the meantime, don't give appointments.
No, nothing. We are not, because I tell you, another example. This Malad B.Ed candidate, somebody when the division bench order, it's a very nice case. So some division bench order passed, no, you can't take them. Somebody of them are also B.Ed. At that point of time, B.Ed was allowed. They came up before the court. Look, because of the advertisement, I applied under undergoing candidate. Now, because of the division bench, I can't pursue. Allow me to pursue. I have B.Ed. At that point of time, B.Ed was valid. Immediately, they edited their form pursuant to the order. Just after that, Supreme Court says B.Ed is disqualified. Now, they are now again coming. I has to be allowed. So, board cannot do it within the month, within 2 months, 3 months. It will take time.
Petitioners in the matter.
Kindly do not make any open submissions today. Just your losses considered. I'm just taking your losses.
Affidavit service filed on behalf of the petitioners is taken on record. Documents are also submitted in support of depositing deficit court fees. Since there are how many petitioners? Since there are 14 petitioners. Next paragraph. Petitioners participated in the selection process for being appointed as primary teacher pursuant to notification dated 29 September 2022 issued by the concerned authority of the West Bengal Board of Primary Education. Stop. It is submitted by the learned advocates representing the parties, learned advocates representing the petitioners as well as West Bengal Board of Primary Education, that controversy arose whether candidates who were pursuing DLED course for the session 2020-2022 are to be included in the said selection, are to be considered for the said selection for the said selection process, which commenced pursuant to notification dated 29 September 2022. Stop. It is submitted that initially these candidates were permitted to offer their candidature for being appointed as primary teacher, but subsequently litigations subsequently issue was considered by the coordinate bench, and thereafter the decision was thereafter order was passed by the honorable division bench, by which the candidates who were pursuing DLED course for the session 2020-2022 were required to be excluded from consideration for being appointed in the post of primary teacher pursuant to employment notification dated 29 September 2022. Stop. Issue traveled before the Honorable Supreme Court and final order was passed
4th April 2025.
Just a order was passed on 4th April 2025. Stop. It is submitted by the learned advocate representing the petitioners that in terms of the final order of the Honorable Supreme Court dated 4th April 2025, passed in civil appeal arising out of SLP within bracket C number 12660 of 2023 within bracket Shoumen Pal and others versus Shaboni Naik and others. West Bengal Board of Primary Education is required to consider the candidature of those candidates who were pursuing DLED course for the session 2020-2022. Stop. Next paragraph. Present petitioners completed DLED course prior to 2020.
Yes, my lord.
Prior to 2020, and they were also allowed, and they participated in the selection process pursuant to employment notification dated 29 September 2022, but they did not come within the zone of consideration while giving appointments to similarly circumstanced other candidates. From the total other candidates, while filling up the post of
9,533.
While filling up the post of 9,533.
Yes, your lordship.
They were not coming in the zone of consideration.
33. Stop. It needs to be recorded herein that petitioners preferred implement application before the Honorable Supreme Court, which were dismissed as withdrawn by order dated 4th April 2025. Stop. But on perusal of paragraph 34 of order dated 4th April 2025, it further appears that those candidates who filed implement applications were permitted to avail such remedies as are available to them in law. Stop. It is submitted by learned advocate representing the petitioners that based on leave granted by the Honorable Supreme Court video order dated 4th April 2025, present writ petition has been instituted seeking consideration of their candidature along with candidates who participated, who were pursuing DLED course for the session 2020-2022 and participated in the selection process pursuant to employment notification dated 29 September 2022. Stop. Next paragraph. Mr. Shannal, learned senior advocate representing West Bengal Board of Primary Education, has prayed for accommodation to obtain instruction and instructions regarding the stand of board while giving appointment, while filling up the posts which are lying vacant in connection with the selection process initiated in 2022, and whether present petitioners are to be considered along with candidates who were pursuing DLED course for the session 2020-2022. Stop. Next paragraph. In order to enable the learned advocate for the board to obtain instructions, hearing of this matter stands urgent. List the matter under the heading, under the same heading, on 17th June 2025.